Good afternoon, everyone. I would like to welcome you into this cybercrime and digital evidence workshop. We're about to start in a few minutes. We are just allowing time for those who are not yet on to be able to join us. We shall just do a recap of last week. The first session that we had. The first session that we had, we're looking at what cybercrime is and some of the investigative tools of cybercrime. That session, for those who missed it, it's available on the East African Law Society Facebook page online. It's available on the East African Law Society page online. So you could get onto the East African Law Society page at LSP Nairobi, and you'll be able to access the previous session. Today's session will be going into digital evidence, and Lawrence will be taking us through. So would like to welcome all the attendees today. You could also share the link with your colleagues to be able to join in. Thank you so much.
Well, thank you very much, Amy. I think we can commence in about 2 minutes. We are allowing as many people in as possible before our presenter kicks off this second session.
Yeah, thank you so much, David. We're reminding the people who are joining that if they missed the first session that we had 2 weeks back on what entails cybercrime and the investigative tools, they can access it on the East African Law Society Facebook page. It's available. There was a live recording. So if you missed the first session and you're interested in catching up on it, you can access it on the social media page, Facebook page of East African Law Society and LSK's page. Thank you, but we shall be starting anytime soon, and Lawrence will be taking us through. And this time we shall be looking at digital evidence and its admissibility before the courts. So you could send the link to some of your colleagues and invite them, since you know we are living in a digital era and everything has moved online. And most of the issues we are having right now, the cases you find that entail being able to adduce digital evidence before court. You may be a purely commercial lawyer and you're saying that cybercrime, it sounds criminal, but you'll notice that even as a commercial lawyer, today the evidence that you're having to adduce before court, most of it is digital evidence, and some of the tips you'll be able to learn here will be sufficient to help you to be able to break through with that. So kindly call in your friends to join as we share information across the jurisdictions. We have Uganda represented, we have Kenya represented, we have Tanzania represented. So we can start off shortly.
Well, thank you very much, Amy. We also have the recording of the first session on our YouTube page. So for those that missed that very first session, that very first important introductory session, you can check out our East Africa Law Society YouTube channel, and you will be able to get the recording. It's the entire recording, the entire 2 hours. So you can easily catch up with us even after this session. So Lawrence, I would like to welcome you. It's 15:10 to kick this off. I know more people are joining as we continue with the session, so they will find us on the way. Welcome our trainer, Mr. Dinga.
Thank you very much, David. Today, let me just share my screen. Thank you, David, for this session today. Welcome to this session, ladies and gentlemen. Today, we are going to look at part 2 of cybercrime and electronic evidence workshop. And part 2, we are going to concentrate on digital evidence. For the introduction, I think David did it last week. I don't know what, David, you need to do the introduction again?
Well, Lawrence, I don't think we need to do that again. We can probably just do a recap of what you covered last time. We do not necessarily need an introduction. This session is a partnership between the East Africa Law Society and the Law Society of Kenya, Nairobi branch, as well as Managecom Systems, which you are the director, and you deal with electronic evidence issues, and you are an expert in that area. Probably you can just talk a little bit about yourself for those that were not here last time, as well as do the recap. In case someone will need your services, I know sometimes we need the services of experts. As lawyers in our law practice, when we get evidence of this nature and we get the confusion, how do I handle this? How do I present this in court? So probably you can just highlight just 1 minute about yourself, and probably if you can provide or help anyone that has issues to do with digital evidence, forensic evidence, especially when it comes to court. I know lawyers mostly do this.
Okay. Thank you for that, David. Ladies and gentlemen, my name is Lawrence Dinga. And for those who are here last week, I think David did the introduction. Basically, I'm a digital forensics and cybersecurity consultant. And I deal mainly with investigations, as well as capacity building. So in the areas of capacity building, I do train lawyers, I do train magistrates and judges and prosecutors on, cybercrime and electronic evidence. I am an approved consultant for the Council of Europe, that is in the areas of electronic evidence and cybercrime. So basically, I don't have much about myself. I think in case you need more information, you can just contact me. My telephone number is actually on the screen. My email address is on the screen. So in case you need any help in terms of electronic evidence or forensic investigation, where you have a case that involves investigation and presentation of that evidence in court, then you can contact me and I can be able to help you. Or sometimes you find that you are a defense attorney and the other party has brought in evidence which is touching on electronic evidence, and you would like somebody to review that evidence and give counter opinion about that evidence, so that it can tilt favor against on your case. That one also you can help me. You can call on me and I can help you to do that. So basically today we are going to look at digital evidence. Now, what is the agenda for today? Now, agenda for today, we are going to look at the definition of digital evidence. When we talk about digital evidence, what is it? Then we are going to discuss the issues of admissibility of digital evidence in judicial proceedings in terms of its authenticity, in terms of its reliability, in terms of its relevance, credibility, and integrity. Then we are also going to look at the principles of best practices relating to seizure and handling of digital evidence. You know, digital evidence is volatile, as we are going to see, and should be collected in a way that it's going to be admissible in court of law. So by the time you're seizing that evidence, the way you are handling that evidence really matters when it comes to the time that you are presenting that evidence in the court of law. Then we are also going to identify the challenges offered by dead box and live data and internet sources of digital evidence. When we talk about dead box, here is a case whereby an investigator has gone to a site and has found a computer which is probably the suspect computer, and you need to extract evidence from that computer, and that computer at that particular time is actually switched off. So that is, you are collecting evidence from a computer which is switched off. That is what we call dead box forensics. Now, sometimes it forces you, when you go to a site and the computer or the device that you are going to, the suspect device that has got the data cannot be taken from the site. And it forces you to get the data from that computer while it is running. Now, that is what we call live data or live forensics. We are also going to see how do you collect internet sources of digital evidence. Then we are going to look at identify the challenges of obtaining evidence from another jurisdiction. You see, it becomes complicated, especially when now the evidence you are looking at or to collect is found in another jurisdiction. How do you go about that? So those are that is the agenda for today. That's what we are going to look at today. So let's just start. Now, what is digital evidence? Now, by definition, it is any information generated, stored, or transmitted in digital form that may later be needed to prove or disprove a fact disputed in a legal proceedings. So digital evidence is derived from digital devices such as computers and their peripheral apparatus. We also can derive digital evidence from networks, mobile phones, digital cameras, or any other digital storage media, as well as the internet. So that is actually the definition of, when we talk about digital evidence, that is the definition of digital evidence. This evidence, you need it to prove or disprove a fact which is disputed in a legal proceedings. Now, digital evidence is found in files such as graphic files. You can find digital evidence on video files, audio files, emails, server logs, word processing documents, spreadsheet files, internet browser history, log files. So within a computer, there are so many areas where that could possibly be digital evidence that you need to collect and present in the court of law. So what is the role of digital evidence when we are talking about investigation? The role of digital evidence is actually to establish a credible link between the attacker, the victim, and the crime scene. Because here we have somebody who has done a crime, who has committed a crime. Now we have a victim. A victim, as we saw last week, could be a computer which is being attacked, and the crime scene. So the digital evidence, the role of digital evidence will be able to link. If you will do the investigation, you'll be able to link from that evidence, you'll be able to link the attacker and the victim as well as the crime scene. Now, this is illustrated by what we call, what nowadays we call Locard exchange principle, or sometimes we just call it Locard principles of transference. Now, Locard principle of transference is a forensic science principle, which was invented by Edmund Locard, who lived, I think, between 1897 to 1966. Now, the Locard exchange principle states that anyone or anything entering a crime scene takes something of a crime scene with them and leaves something of themselves behind when they leave. Now, what this means is that whenever anybody, let's say a criminal goes to a place to commit murder, now this person, by the time, let's say this person is not wearing any gloves, when this person touches the handle of the door, is using the DNA flakes on that particular door, and that can be used as an evidence. This person may use a knife, which is found in the kitchen, and by the time it touches the handle of the knife, is leaving his DNA on the knife. Now, this person, the person he has killed, maybe by the time of during the commotion, they are exchanging DNA flakes between them. And by the time the criminal is leaving the scene, he has already left some DNA in the crime scene and has also taken some DNA of the victim with him. Now, this principle also applies to digital evidence, because remember, everything you do on a computer or a network leaves traces, from deleted files and registry entries to the internet history cache. Now, those who do not know, when you visit a site, the browser is going to log everything that all the sites that you've visited. So when you are sending an email, there's what we call email headers, which will show the logs, which gives clue for the as to the immediate servers through which that information traversed. So if you're sending an email from Kenya to somebody in the US, that email, just like the normal snail mail, it moves from one post office to the other. And that post office in this instance of digital era is represented by a server. So your email is moving from one server to the next, hopping from one server to the next server until it reaches the destination. And that is, when it does that, it leaves the log on that particular, on those particular servers, what we call email headers. Also, when you visit a site, or you come in the morning and log on to your network, there's server log which provides information about each and every computer which was accessing the system. So when we talk about Locard exchange principle, as much as it is an old principle in forensic science, it applies very well and very well in digital evidence. Now, when we talk about digital evidence, what are some of the challenges of digital evidence? As I said earlier, we said that digital evidence is volatile, which means it can quickly disappear by being overwritten or deleted. Just by a stroke of a key, the evidence can get lost. Sometimes the evidence that is stored in the memory, what is called the random access memory, that is memory that disappears when the computer is switched off. So when your computer is on, there's information that is stored in the random access memory. So when you switch that computer off, that information is lost. So that is why we say that digital evidence is highly volatile, And if it is not handled properly, it can disappear, and that leaves you with nothing to present to the court of law. There's also the issue of fragility. The digital evidence is susceptible to alteration and can easily be manipulated, altered, and damaged. Now, so the process of collecting that evidence must therefore be methodical and systematic, which means here, if we say that you go to a site and you found the evidence, now the fact that you can slot a USB in that on that particular computer and copy and paste into the USB, that already means that you've changed the evidence, that evidence, because there's what we call the metadata. Metadata is data about data. If I have a document which is, let's say, a Word document, that Word document has got the content and has got information about that particular Word document. For example, the date when it was created, the time when it was created, that is metadata. So when I go to a computer and I find evidence, I say, this is the evidence on the screen, and I slot my USB and copy that evidence from the hard disk to my USB. Already I've interfered with that evidence because I've changed and I've manipulated it in terms of the dates that the dates of the original evidence. There also the issue of decentralized storage. The availability of cloud remote storage servers has influenced the way information is being stored. Now, when we talk about the collection of evidence, here is a case where you go to a company and you find these are the computers that are about evidence, and now you can copy evidence in a forensically valid manner. But what about if that evidence is not on those servers? Those evidence are stored somewhere on the internet or on the cloud. So you need this decentralization. This cloud has also brought another issue, another challenge when it comes to digital evidence. Now, there's also the issue of speed of technical development. So technical development is continuing at a very fast pace. So significant number of development pose new challenges with regard to forensic examination. Now, for example, right now, when you look at the kind of hard disks that we used to have, they were magnetic hard disks. They are magnetic. Actually, the data is stored in what we call sectors on a magnetic plate. Now, the new hard disks are now, new computers are coming with new hard disks, which are called SSD. Now, this SSD has a challenge when it comes to digital forensics. That can just be another topic of another day. So technological development has got a huge effect, challenge in digital evidence. Now, let's look at the admissibility of evidence. Now, for this evidence to be admitted in the court of law, it must meet some characteristics. There must be some criteria that the court must use to admit this digital evidence. So digital evidence must be collected in compliance with existing national legislation and best practices to ensure admissibility at the trial. Now, what we mean here is that each and every country has got some piece of legislation which prescribes how that evidence should be able to be collected. And without that, it becomes difficult when the evidence is presented in the court of law. Now, some of these criteria that the court will actually be looking at is the legal authority. Who the investigator must have the legal authority to collect that evidence. So the investigator must ensure that they have the legal authority to acquire and collect evidence, because evidence that is not that's collected without legal authority will not be admissible in the court of law. I'll give you an example. I don't want anybody to take me in a political connotation, but I'll just give you an example. During our 2017 election, general election, presidential election, there was the issue of server being interfered with, and the opposition was saying that evidence, they had evidence that the server had been interfered with, and you can remember the right former Prime Minister Raila Amolo Odinga came to the live TV with another guy who was an expert, and they said that they had evidence that the election had been stolen. Don't take me politically. Now, what I'm trying to say here is that at that point, if they could have presented that evidence in the court of law, it could not have been admissible, because the court will ask, how did you obtain this evidence? Did you have the legal authority to collect that evidence the way you collected it? So any evidence that is collected without legal authority will always be not admissible in court of law. The other characteristics is, or criteria, is what we call authenticity. Now, authenticity means that it must be shown that the evidence is what it purports to be. Authentic means that it is genuine and matches the claims what it claims to be. So authenticity of that evidence is paramount when it is being presented in the court of law. The other criteria is relevance. Now, forensic relevance is determined whether the digital evidence establishes a credible link between the perpetrator and the target or the crime scene. We've talked about that. So we can say that this evidence is relevant because you can create that link between the perpetrator, the victim, and the crime scene. There's also the criteria of integrity. The evidence must have the integrity. There must be proof that the evidence has not been altered either inadvertently or intentionally. You can be able to prove to the court that this evidence has not been interfered with. This evidence is the way we collected this, integrity. The other thing is what we call the reliability. There must be nothing about the way in which the evidence was collected and subsequently handled that can cast doubt on authenticity or veracity of that evidence. Now, to ensure that this reliability, it is often advocated that the disk imaging or the process of collecting that evidence, copying that evidence, must include what we call audit trail. That clearly records the successes or failures of all or any part of the copying process. Then we'll be able to know that this evidence is reliable. So which means that when you bring your investigation in the court of law, and for you to prove this reliability, that evidence, that audit trail must be attached to the evidence. How you collected it, how you did your disk imaging, you have to put that, audit trail, or keep it in such a way that when the court requires it, it will be able to be availed. Then the other aspect is credibility. Now, credibility is a measure of a witness and whether or not the witness is worthy of belief. A witness might be considered credible if they have reliable information about an event. Now, for the court to establish credibility, the person who is bringing the evidence in court must testify in court about their qualification, the qualifications they possess, the investigatory standards that they employed when they were collecting the evidence. They also must be able to prove that the method they used to preserve that evidence before they brought it in court. So the qualification of digital experts are also examined to establish competency of individual handling and analyzing evidence, and whether that competence, competency of those experts are verified and tested. So credibility is more about the person who is collecting that evidence. The investigator himself, is he qualified? Because if the court can, this is a new area. This is scientific method. If the court cannot establish whether you are qualified, you have the necessary qualification, either through experience, through practice, or through academic qualification, then the credibility of that evidence that you brought is in doubt. Now, the last one is called the validity. Now, the validity of evidence is one way to demonstrate that digital evidence is reliable is by showing that it was collected in a valid manner, whether the scientific principles were used to preserve it, acquire and analyze that digital evidence, and whether standards were met to handle and examine the digital evidence. So validity is very important because it determines whether scientific principles which you used to preserve, acquire, and analyze evidence were met, and the evidence was handled scientifically. It also looks at the laboratory. Digital forensic laboratory is also examined to determine whether there's the competency of laboratory in handling and analyzing the evidence and producing reliable results. So that's where we can say that it is the validity of that evidence is can be established. So when we talk about authentication of evidence, we say that evidence needs to be authentic. Sorry, I don't know what's happening here. Yeah. Sorry for that. Now, when we talk about authentication, we say that the evidence must be able to prove that it is what it is. That is, evidence is authentic. Now, when we talk about evidence, we are talking about content. So content generated by, there's always content generated by one person or the other. Something like email or instant messages or word processing documents, such as these are content that somebody generates when they are working with a computer. There's also content generated by a computer or digital device without user input. Now, there's also content generated by a combination of both. That is something like a spreadsheet from programs such as Microsoft Excel, which include user input as well as calculating made by the software. So when we talk about authentication of evidence, device-generated evidence can be admitted if it can be shown to that the device itself is functioning properly at the time the evidence was produced, and if it can be shown that when the evidence was generated, security mechanisms were present to prevent alteration of that evidence. That is evidence that is device-generated. Now, user-generated content can be admissible if it can be proved that it is trustworthy and reliable, which means that it can be attributed to a person. So that is how you can be able to authenticate that evidence. Now, so before any evidence is admissible in the court of law, it must be authenticated. In a case which is, I put on the screen, in Republic versus Mark Lloyd, Stevenson, 2016, the High Court ruled that email in question and the attached document were properly excluded from evidence by the magistrate court as they were not properly authenticated. So which means authentication is very important. So it would have been appropriate for the expert to lay the foundation by authenticating emails through email technological footprints. Now, this is the technology that, how do you actually authenticate that this mail is valid? Because an email is based on what we call SMTP, and SMTP is a very weak protocol, and somebody can generate an email and pretend that that email actually came from you. So authentication is required where any real evidence is being adduced in code. Now, I've just given an email that was sent. You can see that email, the title is opening account, and it is to so-and-so, CC so-and-so, and then the content of email. Now, if I want to authenticate this email, I can run it through the email analyzer, and what I produce is what we call the email header information. And then email header information, if you look at that, dissecting that email header, you can see the return path. It will tell me where that email, if it bounces, it goes back to who. You can see what we call the DKIM signature, which is very important for all email clients or email servers to maintain, so that they know that this signature is attributed to this particular server. You can also see number 3 there, where it's talking about the email ID. Now, this email ID, in case you go to this server that was hosting that email, you can request that particular copy of email using that particular string of text. That is number 3. You can also see that this email was composed using iPad, that on number 4. And then you can also see this email was addressed to. So this is a way, just an example of authenticating an email evidence. Now, there's also what we call the principles of digital evidence. When you talk about principles of digital evidence, here we are saying that the digital evidence must meet some principles when you are investigating bringing those evidence to court of law. Now, principle number 1, but this principle were actually crafted by what we call ACPO. ACPO means the Association of Chief Police Officers. Now, they were crafted long, sometimes back when for the digital forensics had not even taken this pace. So these guys had four principles. The ACPO, sometimes we call them ACPO principles. Now, principle number 1 says that no action taken by law enforcement or agencies, persons employed within those agencies or their agents should be able to change the data which is subsequently to be relied upon in court. Now, what this principle says is this: the acquisition and subsequent analysis of electronic data has to be undertaken with all due regard to preserving the data in state in which it was first discovered. So when you are doing all this analysis, the process, the forensic process of this doing all analysis should not in any way diminish the evidentiary value of electronic data through any technical, through any procedural, through or any interpretive errors. So when data is accessed in a live computer system, whereby you don't go to a computer system and you cannot take it out of where it is, then it should be done in a manner that causes least impact on the data, and the person doing that must be able to be qualified to do so. So that is principle number 1. No action. If anything can prove to the court that there's some change on the evidence that you brought to court, then that evidence is not going to be admissible. Principle number 2 says that in circumstances where a person finds it necessary to access original data, that person must be competent to do so and be able to give evidence explaining the relevance and the implication of their action. Now, what means that here sometimes you are dealing you are dealing with evidence which is not stored locally on that particular computer, but it is stored remotely. So it is not able, you are not able to access it. It is inaccessible. So in that case, it may be necessary, it may become necessary for the original data to be directly accessed to recover the evidence. With this in mind, it is essential that the person doing so, or the person retrieving that particular evidence, must be able to give an explanation to the court why he did that and the consequences of doing that. Because here, remember, is accessing the original evidence. How sure are you that he did not change that original evidence? So that must be explained in the court of law. And that is what it says, that it must be able to give evidence explaining relevance and the implication of their actions. Principle number 3 says that an audit trail or other record of processes applied to digital evidence should be created and preserved. An independent third party should be able to examine those processes and achieve the same results. Now, here we are talking about auditability, the audit trail, which means that there must be objectivity. There must be objectivity in court of law, as well as continuity and integrity of evidence. So it is necessary to demonstrate how evidence had been recovered, showing each process through which the evidence was obtained. Now, evidence should be preserved to such an extent that the third party is able to repeat the same process and arrive at the same result as presented in the court of law. Now, this is why it is always advised when you are collecting evidence, you don't analyze the original evidence, because the original evidence is preserved and will be brought to court so that the third party, maybe if you are on prosecution and you brought the evidence, then the defense can say that we do not agree with these results. So you should be able to give them the original evidence. They should repeat the same process and they should be able to reach at the same result. So auditability is very, very important to prove objectivity in a court of law. Now, principle number 4 says that the person in charge of the investigation has the overall responsibility of ensuring that the law and these principles are adhered to. Now, what kind of evidence are we talking about here? When you're collecting evidence, first of all, you must know that evidence is volatile. So we have volatile data. This is data that can easily be lost when the device is shut down. It is contained in the RAM. So which means that when you go to a place and you find that the computer is on, do not shut down that computer, because that there are issues, challenges. When that computer is on, there's data, like what you are seeing on my screen is data in the RAM. Now, if I shut down this computer, I'll not lose all this data. So when you go to a place, make sure that you can first collect the volatile data from the memory. So that is what we call memory forensics. And there are tools that are going to allow you to do that. Then we have what we call the non-volatile data. This is data that survives after process with which it was created is ended. For example, when you create a Word document and you save that Word document, it is permanently saved on the hard disk. So that is a non-volatile data, and you can be able to get that data later on through forensic process. Then we have the transient data. That data is which is created within an application session, which is not saved in the database after the application is terminated. This includes network connections and user login and logout. So like this transient data, we remember last week we were talking about preservation, and we talked about the content data, and we talked about the traffic data. Now, in most countries, you find that there's no legal framework for data retention, for retaining the transient data or the traffic data. So you need to know how to collect this data. You must have a way of collecting this data. Then we have what we call residual data, the data that is stored on a computer when a document is deleted. Now, I want to bring something to your attention. In a computer environment, when you say delete a file, that file is never deleted. Now, the way computer stores data is like if you go to, you get a book, and when you get a book, the first page you'll get a book is the table of contents, which tells you what the content of that book and which page that each and every content is stored. So if I want introduction, it will be page 1. If I want about this story, is page 6. So that is how computer stores data. Computer stores data on a hard disk in sectors. Now, what happens is that when you delete a file, the operating system, be it Windows, be it Linux, what it does, it marks the space where that file was residing to be an empty, but it is not deleting that file. So what happens is that if I had a file of size, let's say 300 kilobytes, and I delete that file, and then what the operating system will say that at the time I delete that file, there's a space of 300 kilobytes that is existing on the hard disk. But in actual sense, that file is not deleted. So when I bring a file that is 200 kilobytes and I copy into that file, on that hard disk, what the operating system will do, it will take this 200 kilobyte file and copy in the place of 300 kilobyte file that was deleted. However, as you can see, the 300 and 200, there's some space which is remaining. And this space which is remaining has got some information about the file that you deleted. This is what we call slack spaces. So these are residual data. That is why when always you delete a file, don't think that it is in the recycle bin and you remove it from the recycle bin, then it is gone. No, it is not gone. You can still use forensic process to get the remnants of the files that were deleted. Those are what we call residual data, and that is why forensic process is very important. Then we have the metadata, that is a record about particular document, including the format of that file. If it is a picture, is it a JPG? When was it created? By who was the author? Such thing, that is metadata, data about data. So those are some of the evidence that you can always collect when you are doing your forensic process. Now, what are some of the rules of digital evidence? First, digital evidence must be collected in compliance with the existing national legislation, and details may differ from jurisdiction to the jurisdiction. And that is one of the problems that we have now with the digital evidence, because each and every country has got their own laws of how to collect that evidence. Now, evidence that has to be presented in the court must comply with the established rules of evidence. So there's no way you are going to present the evidence in court of law if you are not complying with the rules of evidence in Kenya's context. So rules of evidence will govern whether, when, how, and for what purpose proof of a case may be placed before the trial of fact or for consideration. Also, best evidence rule is established to prevent any alteration of digital evidence, either intentional or unintentionally. And also, the last rule is that the best evidence is the original piece of evidence or an accurate duplicate copy of the original. So that is why I said that when you go to a place, you get to a computer, you slot your USB, and you copy the evidence, copy and paste. That you already, if that is your evidence that you are bringing to court, already you've interfered with it, because it is not the same as the original. When you copy to USB, it's going to take the current date of copy. So when you bring that to court of law, you'll just be told that this evidence was created, this file was created in 2018, but the file that you are bringing to us is created in 2020. So you see that it is not the original evidence. The way you should be able to get that evidence is using what we call duplicating the original evidence bit by bit, which we call the bit by bit copy of the hard disk or of the original device. So now, what are some of the admissibility challenges in evidence when we talk about digital evidence? So we use it interchangeably. Sometimes we say electronic evidence or digital evidence. So it is fragile. We've talked about maintaining integrity is also a problem with many law enforcement, and also proper procedures need to be followed to obtain evidence from defenders' computer in a manner that is legally admissible in court of law. If you go somewhere and you just get in there without a warrant and you bring that evidence without legal authority, it will not be admitted. Law enforcement investigators lack essential technical training and expertise to effectively gather electronic evidence. Now, this is something that is global challenge. It's not only in Kenya, it is not only in Uganda, it's not only in Rwanda, it's a global challenge. You remember, digital forensics is a new discipline. And you find that many law enforcement still do not even have proper laboratory to investigate these cases. Many of them have not been trained on how to effectively gather electronic evidence. So this is a global challenge, not only by a particular country. Also, there's also what we call lack of legislation. Now, lack of legislation, in some jurisdictions, laws are enacted long before the evolution of computers. So current laws, sometimes you find that they fall short of addressing computer misuse, especially those involving the internet. Now, Kenya, we just passed the Computer Misuse and Cybercrime Act 2018, but you find that in many countries, they still do lack this kind of pieces of legislation. So you find that many countries still lack relevant laws to prosecute cyber and computer related crime. This is evidence, like in 2000, the guy who created the love bug or the virus called I Love You. When he was taken to court by the Philippine authority, they could not charge him with anything because there was no legislation on computer espionage in the Philippines at that particular time to charge this person. So that is a real problem when it comes to admissibility of evidence. Now, let's look at our pieces of legislation when we talk about electronic evidence. Now, let's look at Section 65, subsection 8 of the Evidence Act. What does it say? Now, it says that a computer printout or statement in evidence must be accompanied by a certificate doing any of the following. The certificate must be able to identify a document containing a printout or statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that document as may be appropriate for the purpose of showing that the document was produced by a computer, and also dealing with any matters to which conditions mentioned above relate. Now, this means that when you are taking a computer printout as evidence, then you have to follow this section 65, 65B, subsection 8. Now, also, when there's also section 78A. Now, section 78A is read with section 100, section 104. We are going to see that. Now, this relates to evidence such as from WhatsApp, from SMS. So what it says that the Act recognizes and endorses the use of electronic evidence and reiterates the condition for admissibility of this evidence. In any legal proceedings, electronic messages and digital materials shall be admissible as evidence. So this, we are talking about SMS, WhatsApp, things like that. Now, the court shall not deny admissibility of evidence only on the ground that it is not in its original form. So the weight attached to electronic evidence and digital evidence is determined by reliability on how it was generated, stored, and communicated, how it was preserved, the originator was identified, and other relevant factors. So, but what I say, this section is actually read by with section 106B subsection 4, which is talking about what we call a certificate. So it's saying that there are conditions in order to certify the court. Now, the electronic record was produced, fed into, or derived from the computer in the ordinary course of business by a person having lawful control over the computer. Now, the computer was operating properly, and if there was in any way it was not operating properly, then such malfunction was not of such nature as to affect the evidence itself. So there must be certificate by a person occupying the responsible position in relation to the operation of the relevant device and the manager of relevant activities. So here, what it says that when you are presenting any evidence in the court of law, be it those we've talked about messaging or any evidence that is derived from computer, it must be accompanied by the certificate as per section 106B subsection 4. Now, what is the function of this particular certificate? It's identifying the electronic record containing the statement and describing the manner in which it was produced, giving such particular of any device involved in the production of the electronic evidence and may be appropriate for the purpose of showing that the electronic evidence was produced by the computer, dealing such matters to which conditions mentioned in 2 relate. Now, and purporting to be signed by a person occupying a responsible position in relation to the operation of the relevant device or management of relevant activities. So you need to present that with a certificate according to section 106B. Now, let's look at some of the cases where which have been brought to court. Rasanga and Odwol 2014. Now, here we had the witness testimony, which was backed by a CD and was said to carry a video clip he captured using his Nokia phone. It contained a footage of an election clerk with marked ballot papers preparing to stuff them in the ballot box. the clip had been transferred from a phone to a disk without a certificate. The witness, being the owner of the phone, did not say anything about its working condition. So no evidence regarding the computer which was used to create the CD and its condition and reliability. There was no evidence to show that he was the one who owned, operated, and managed the computer. The condition of any device used in the process, creating it, and the signature of the person who was in legal possession of that particular gadget. So what did Justice Mutelule noted, say? Now, the person who had copied the clip from the phone to the computer had not created such a certificate to make the CD acceptable. So the reason for particulars of the computers used in production of the CD had to be given so that such particular would include the MAC serial numbers so that it becomes necessary that you can be able to trace those devices for audit purposes. So the ruling was in favor of Rasanga. So that is how you can see the consequences of not producing evidence. Another one is the Republic versus Wilfred Machage. This was a case which was related to words allegedly uttered by the accused at a political rally in 2010. Now, the journalist had transferred the footage from his Mac computer at K24, edited it, and used it to run the news in the evening. So what happened is that when the investigators came, the K24 management authorized the footage and the news to be released to the investigators, who ultimately produce it in court of law. Now, the electronic evidence footage that the prosecutor intended to rely on was made by a journalist, and the journalist was not called as the witness. So since the maker of the record was not called as the witness, it was held that the footage was mere hearsay. Now, the prosecution failed to show a certificate signed by the person who had direct control of the device and which was used to generate the evidence. So eventually, you see, so that the content of the electronic recording had not been proved in accordance with the Evidence Act, and being that this evidence was crucial and its omission was fatal to the prosecution case. So that is also the issue of evidence. Now, the last one which we will look at is that one of Julius Macau Malombe and two others in 2018. So those certificate was produced showing the compliance and authentication as required by sections 106B of the Act. So it was held that the certificate is required for the purpose of reliability, authentication, and integrity of the evidence in terms of disclosing the source of the material, how the material was handled, how the report was generated. So the certificate must uniquely identify the original electronic evidence record, describe the manner of its creation, describe the particulars of the device that created it, and certify compliance with conditions in subsection 2 of section 106B. So those are some of the cases that we can say post-challenge to prosecution in terms of digital evidence. Now, what are some of the international organizations doing along this computer evidence? Now, we have the International Organization of on Computer Evidence, and this organization was established in 2005 with the purpose of providing a forum for global law enforcement agency for exchanging information regarding cybercrime investigation and other issues. Now, what IOC did is that they developed some principles, and they hope that this principle can apply in all jurisdictions. So this principle were meant to have the following attributes: consistency with legal systems, which means that what they were looking at, if you have collect evidence in Uganda, can you bring that evidence in court of law in Kenya without having to, again, subjecting it to analysis? So it was looking at consistency with legal systems. It was all looking at allowance for use of common language, ability to cross international boundaries, and also ability to instill confidence in the integrity of evidence. So this was some work of the IOCE to make sure that evidence can be used by prosecution across the border. Now, what this IOC says here is these are some of the principles we've talked about. When dealing with digital evidence, all the general forensic and procedural principle must apply. It's also saying upon seizing the digital evidence, action action taken should not change the evidence. When it is necessary for a person to access the original evidence, that person must be trained to do so. All activities relating to seizure, access, storage, and transfer of digital evidence must be fully documented, preserved, and available for review. And also, an individual is responsible for the action taken with respect to digital evidence, whilst the digital evidence in their possession. And number 6 is talking about any agency that is responsible for seizing, accessing, storing, transferring digital evidence is responsible for these principles to be maintained. We also have the Scientific Working Group on Digital Evidence. This is a group which is actively engaged in the field of digital and multimedia evidence to foster communication and cooperation, as well as to ensure equality and consistency within forensic community. Now, it has also 6 principles, but the only principle that I saw relevant is principle number 1, that says that in order to ensure that the digital evidence is collected, preserved, examined, and transferred in a manner safeguarding the accuracy and reliability of that evidence, law enforcement and forensic organization must establish and maintain an effective quality system. Here we are talking about trying any law enforcement capping up with what we call the standard operating procedures on how you are going to handle the evidence. Okay, now sources of evidence, you can see there, I've put a lot of images of where you can get those evidence, hard disk, how the hard disk looks like. This is the old mechanism of hard disks where you are using magnetic plates. We also have the solid state disks right now. Then we have the compact disks. So these are some of the sources of evidence. We have the memory cards. We have the USB storage devices. We have the peripheral devices. These are all sources of data. And nobody should cheat you that when you print something on a printer, then once printed, data is lost. That data is still in that particular printer, and somebody can use the forensic processes to obtain that particular data. We also have the tablets. We also have mobile phones. We also have the cameras. These are all digital sources of data. So where can you find that? What forms of data can you find? You can find things like documents. You can find things like photos, emails, attachments, databases, financial information. So these are some of the digital evidence when you are potential evidence that you can look at when you are doing your investigation. Now, let's get into seizure of digital evidence, types of seizure. Now, when I was starting, I was explaining the agenda. We talked about what we call dead box. Now, there are several types of electronic evidence seizure, but what we are going to look at, let's look at what we call dead box. Dead box, I said, you are going to collect evidence from a computer which is off. It is not on. And the principle here is when you go to a site and you find the computer is off, let it, do not put it on. Collect the evidence when it is off. Now, the dead box can, three ways. Now, you can do seizure by confiscating the electronic equipment and the storage media. Here is a case whereby you go to a place and there's not much equipment to be confiscated. There are only few equipment. There's only standalone computer or a small network. So it is easier for you to take these computers and go with them to the laboratory and do the investigation. Or in this case, there's no risk of financial or any other losses when you take this computer, because an availability of any of this computer does not affect the operation. Now, also, it is you can use this in a situation whereby confiscation is absolutely necessary and due to the nature of the particular offense. So you need to confiscate this particular computer. Also, it can be necessary, or it can be used where it is necessary to stop. It is necessary to stop any activity supported by equipment that is being confiscated, which means that this computer, this particular equipment, you know that if you leave it, they will still use it to do some things that are not legal. So what are the advantages of doing this, using that process? It can usually be performed without expert, because you just collect those computers, put them in a lorry or on a van, and you go with them. The seizure procedure is usually not time consuming. The electronic evidence is under the control, and the evidence can be analyzed in a controlled environment because you're taking them to the lab. Now, the only disadvantage is that there's risk of damaging the equipment. Remember, when you're handling it, you might damage the equipment, and the equipment, it risks losing your evidence that you are looking for. There's also risk of harming any person because who is unrelated to the crime. I've seen when it comes to going to do the seizure, I did one last year. It is not a very good scene. It's a nasty scene. When you have the warrant, you go with the police and you tell an organization that you want to pick their computers. My friend, it is always not a very good scene. I've witnessed it. It is not good. So that is an advantage, because always blows can fly before you settle to take which computers. So there's also risk of interfering with the activities of unrelated computers. Now, there's also seizure by copying the entire memory content. That is what we call imaging, mirroring. Which means, and this is what we are talking about. It is not a matter of copying and pasting. You must use a proper forensic method of copying this particular data. So for this type of seizure, sometimes it is referred as imaging or mirroring. A special equipment is used to extract duplicate copy of the evidence, which means that this we call it write blockers. Now we have write blockers which are hardware write blockers or software write blockers. Like for this one, you can see the hard disk is on the right hand side, and it is connected to this device. Now this device is a write blocker, which means that is not allowing information to be written back to the disk when it is only allowing one way of writing to collecting this information. This is what we call the copying the entire memory or what we call the disk mirroring. The advantage here, you can use this in cases where the amount of equipment that you need to seize is enormous and you can't seize everything. So you need to copy them. There's also risk of high financial loss Also, there is also the issue that classification of is not deemed to be necessary due to the nature of the particular offense. So you can use that. You can also do seizure by confiscating the backup media. Here is a case whereby you only do selective backup media that you has got evidence. Then we have the live forensics. In live forensics here, I say that you do not have to take the computer to the lab. You need to collect the evidence from the computer there and there. So this is also another way. Now there's also seizure of evidence from the internet. Now seizure from the evidence from the internet is not is something that needs to be guided by some procedure, because you can, this is evidence that can be done through open source, or you can do it by also by covert means. But there must be legal and procedural issues that are relating to this that we cannot discuss now. When it comes to the seizure, the process of the seizure, here you can you prepare for the seizure, you secure the scene, you document the scene, you collect the evidence, pack the evidence, and transport it to the where you need to be analyzed. Now, in preparation for the seizure, you need to assess the likelihood of and the types of evidence that may be encountered, because here you are talking about evidence, maybe for mobile phones, desktop. What evidence are you looking at? So you need to assess that. You need to inform the data recovery team. If you don't have one in place, you need to identify the type of seizure that will be performed. You need to gather information about the IT system, what hardware is there, what OS is there, what kind of application and storage is there, communication network, persons responsible for the IT infrastructure. You also need to look at how equipment is present and will be seized, how much equipment are present there and how many will be seized, how data are there to be copied. So you need to look at all this in order for you to prepare for the seizure. Then also, you need to secure the scene. During securing the scene, you need to protect the data which is perishable physically and electronically. Those data that might be interfered with, you need to protect them. You need to identify that and document related electronic components that will not be collected. You need to identify telephone and network lines attached to the devices. You need to decide if any evidence is required from device to be seized, things like DNA, things like fingerprints. Also, you need to search the scene for non-electronic but related evidence. You need also do an interview for people whom you find in that location. Also, what is important is documenting. Documentation is very important when you are collecting that evidence. You need to document each and everything. So documenting the scene is an ongoing process throughout the entire seizure process. It is of crucial importance to accurately document the location and the condition of the computers, the storage, storage media, other electronic devices, or any conventional evidence. So what is important for you here as an investigator is documentation. Documentation, and more documentation. That is going to help you in the court of law. So when you are documenting, what you need to consider the physical scene. You need to consider look at the computer systems and the electronic components that are connected with them, details of the relevant equipment found, things like the model, the serial number. These people take it for granted. But when you collect, you bring evidence in the court of law, and you say that is coming from this particular hard disk, and that hard disk is not, there's no make, there's no serial number, there's no model, that evidence cannot be accepted in the court of law. So these are some of the things that you need to take into consideration when you are doing documentation. You also in your arsenal, you have to have a camera. The camera is going to help you to photograph whatever is in the scene. Then you also need to make written notes of what is appearing on the screen. If you find that the screen was on, you have to take the photograph of what is on the screen. You have to do a video. You have to make sure that you totally document that site before you actually take those equipment out of the site, because it can bring a problem. One, these guys will say that you have actually interfered with their system. So your documentation is going to help you in the court of law when these people bring any issue against you. Also, when you are collecting evidence, you have to make sure that an IT system should not be seized as evidence just because it happens to be there. So such a measure must be justified and in proportion to the corresponding offense. Therefore, the person who orders the search should make sure a conscious decision whether an item is to be collected by investigating authority. The goodness is that when you are doing the collection of evidence, when you are doing the seizure, the court order must be specific on what you are going to collect. You don't just collect evidence or equipment for the sake of collecting evidence equipment. You have to make sure that you collect what is put on that particular search warrant. Now, electronic evidence, as with any other evidence, must be handled carefully and in a manner that preserves the evidence value. This concerns this concern not just to the physical integrity of the item or device, but also electronic data it contains. So integrity is very important here. We talked about integrity because certain types of electronic evidence or digital evidence can require special collection, packaging, and transportation. You need to be very careful when you are doing this. When you are packaging your computers, the equipment that you've collected, make sure that you have to know that computers and related devices and equipment are fragile, electronic equipment, and are sensitive to temperature. So you have to check the temperature and the humidity. You need to look at the static electricity, because some of remember, the hard disk is magnetic. So when you put a computer where there's magnetic interference, the chances of losing that data is high. So therefore, special precaution should be taken into consideration when you are packaging, when you are transporting, you are storing the electronic evidence or the digital evidence. You need to maintain what we call the chain of custody. That is from the time that evidence is collected to the time that evidence is brought to court of law. Now, I talked about what chain of custody. What is chain of custody? Now, when you are collecting this evidence, you need to manage this evidence. Now, electronic evidence management refers to the administration and control of evidence related to an event so that it can be used to prove the circumstances of the event, and that can prove that this proof can be tested by an independent party with confidence that the evidence was collected is related to the event. So it requires that the evidence is collected in a fashion which does not compromise the nature of evidence, and it is not deliberately or accidentally altered. So integrity is very important here when we are talking about evidence collection. Now, when we talk about chain of custody, it refers to the chronological documentation or paper trail showing the seizure, the custody, the control, the transfer, analysis, and disposition of physical or electronic evidence. From the time that evidence is collected, by the time you receive a search warrant or a court order to collect that evidence, you start the documentation. You have to have a trail, and this is going to be presented to the court of law. So to maintain the chain of custody, you must preserve evidence from the time it is collected to the time it is presented in the court of law. To prove the chain of custody, the forensic investigator should testify in court that the evidence offered in court is the same evidence that was collected or received. So that is the work of chain of custody. They should also be able to testify that the time and the date of the evidence when it was received is actually correct. And when it was transferred to another agency, those dates must be correct dates. Then they should also be able to testify that there was no tampering of with the item while it was in their custody. So chain of custody should be initiated at the time the evidence is collected until the time the evidence is presented to the court of law and the case is over and the evidence is to be destroyed. So evidence should be photographed. We've talked about that. Now, this is the form of chain of custody. I've just given the first part of chain of custody form. You can see, you can put the case number. This is just an example. It is not cast on stone. You can have various information that you need to collect from the chain of custody. Now, that's the second part of chain of custody. You can see that after I've collected the second evidence, the item number 2, I put a dash there and I put final entry so that nobody can come and add another piece of equipment there. Now, when I need to transfer an evidence from one place to the other, I also need to document it. So you can see that in the third part of chain of custody, the item number 2, the date it was received, the date it was released by who, it was received by who, and what happened to it. It was checked in the evidence room. And if it is transferred to another third party, then that needs to be documented. That's the fourth part of chain of custody. Here we are talking about where if the evidence is to be disposed, then there must be authority to do that. If the evidence has to be destroyed, there must be authority to do that. If the evidence has to be released back to the original owner, then there must be an authority to do that. So the last part here is evidence issues in foreign jurisdiction. We really have a problem when we talk about evidence from foreign jurisdiction. When we are doing last part on cybercrime, we talked about preservation order. And this is well articulated in the Budapest Convention. So the problem, the serious issue that we have here is that you need to identify the location of commission of the infringement and identify the competent court and to investigate and hear the case. So if evidence is somebody is in Uganda, has committed a crime in Kenya, how do you deal with that? Now, the problem is if that is not a crime in Uganda, then there will be a problem because the Kenyan government will say, okay, we need to prosecute, but the Uganda government will say, but this is not a crime in Uganda. This is not something we don't consider as a crime. So those are some serious issues when it comes to collecting evidence from foreign jurisdiction. It's a big problem, and that is why we have things like the preservation order. If you look at our Budapest Convention, there are articles. There's article talking about how you can do the preservation order and how you can request for mutual legal assistance, as well as we look at the Kenyan computer misuse and cybercrime bill. You'll also have a situation with articles or section talking about how this international cooperation can allow us to collect evidence from foreign jurisdiction. So that marks the end of my presentation, and I'll hand it over back to Amy to carry on.
Thank you so much, Lawrence, for that presentation. It's a very detailed presentation. And because of time, we are just going to look into the questions that we have and answer the question. Then I think we shall take more questions. Some of them may be answered in the next session before we start off. And also, the slides, Lawrence will avail us with the slides, so that will be sorted. So in this session, for those who joined us and we have already begun, in this session we've been looking at admissibility of digital evidence, the principles of digital evidence, the types of digital evidence, and the chain of custody. And Lawrence also gave us cases from Kenya that talked about the admissibility of digital evidence. So thank you so much for that great presentation. And like we have seen, digital evidence authenticity is one of the biggest issues on the chain of custody. Yes. Now we have a few questions. Some of the questions have been sent through the chat, and I'll ask you to answer some of them. One of the questions that was sent through is that does the residual data have a permanent time limit, or is it permanently stored? And then also, before Lawrence answers that question, I noticed that this is an East African Law Society webinar workshop, and we have people from different jurisdictions. Lawrence has been able to give us the Kenyan jurisdiction. So I would invite someone from Tanzania, from Burundi, from Rwanda, and also from Uganda, if you'd like to comment or share the experience about admissibility of digital evidence, court processes, you're welcome to do that. You can raise your hand and we shall let you speak. Yeah, so I will ask Lawrence just to address that question in about 2 minutes, so that we can have people from other jurisdictions also share their experiences about admissibility of digital evidence.
Can you repeat the question?
Does the residual data have the time limit, or is it permanently stored?
Okay, all right.
I think comes from when you're discussing the types of data, most likely types of digital data.
Yes. Now, I gave an example that the way the computer stores data is like when you look at the table of contents in a book. Now, I gave you an example of where you actually have a file that is the size of 300 kilobytes, and you delete that file. Now, what happens is that the computer the hard disk stores data in what we call sectors. Now, each and every computer hard disk has got various sectors. So each and every sector will be storing a file. So one sector is, I don't know, I'm forgetting. The size of the sector, a file can be stored in so many sectors. So when I say that the 300 KB, let's say it is stored in one sector, okay? And then you delete it and you come and get a file which is 200 KB. What happens is that the 200 KB is going to overwrite the 300 KB, but there's also a section of the former 300 KB which is remaining. So the remaining part will always be there permanently, because there's no any file which is going to be written. If, let's say, this file is written was occupying one sector. So when this 200 KB occupies this sector, there's no any file that is going to come and overwrite the portion that is remaining. So it will be there permanently, and this is what forensics normally call slack space, because they have the residual data that you can be able to get. So this residual data is there permanently, unless again somebody comes with let's say 400 KB and now deletes the 200 KB and writes the 400 KB on that full sector. Then the former 300 KB will all be deleted. So that is deleted permanently, because a file which is bigger is occupying that particular space that it was occupying. Otherwise, that space will be there, residual data will be there permanently. Yes.
Thank you so much, Lawrence. There's a question in the chat group, but I would like to request anyone from any other jurisdiction which is not Kenya to raise their hand and be able to share their experience with using digital evidence before their courts. We know that digital evidence is it's an evolving matter, because this kind of evidence has not been very common. Most of the Evidence Act used to look at evidence in terms of paper. Yeah, but now things are evolving. So we know that there's a lot to learn from different jurisdictions. So would request anyone from a different jurisdiction to be able to share. But what I noted from your presentation is that in Kenya, you need a certificate to be able to adduce that digital evidence before court when you were sharing about the kind of evidence that was adduced during one of those election cases. But for us, at least in Uganda, the biggest issue is about the authenticity of that evidence and how it was obtained. If you're able to prove that the evidence is authentic and it was obtained in a legally okay manner, and the chain of custody was not broken, then it can be admissible before the court. Yeah, so would like to pick experiences from people who have practiced or who have shared some of that evidence for the court, or from the case law that you have read, to be able to share with us. So from what we have noted, Kenya is a bit unique with that. Our Evidence Act does not provide for us to have a particular certificate. The biggest issue for us is authenticity. Yeah, so before we take any other question, you could raise your hand if you want to share your experience and we could let you speak. Okay, Peter Okui, Mohammed Kaketo's hand is up. Mohammed Kaketo's hand is up. If you could let him speak.
Maybe they are muted. You need to unmute them.
Yes. Mohammed Kaketo, you can speak.
I'm sorry, I didn't mean to.
Mohammed Kaketo, you're welcome. You can share with us your experience. Okay, that's the hand that I see up. think it's having a challenge, probably with the network. But when it stabilizes, it can be able to speak to us. Anyone from Tanzania? Okay. Lawrence, we have a question here.
Yeah.
Someone says that since that speaker is based in Kenya, can he take us through the process of getting the court to authorize obtaining of the digital evidence? And while at that, how can you ensure integrity of the evidence you're going to obtain, since the opposing side would have known that you're looking at obtaining advanced evidence to make your case? So the question is about integrity of the evidence and also the process of obtaining authorization from courts, obtain the digital evidence.
When it comes to collecting evidence in a controversial case, what happens is that you need to get a court order for search and seizure. Now, this is what I talked about when I was talking about how you obtain evidence from through a court order. So what happens is that you will go to court. Court will give you an order. In most cases, what I've seen is that like the last one, which we did last year, it was us who actually drafted the court order. So once we drafted the court order and we highlighted exactly what we need to collect, then the order was stamped by the court. It was granted. So you are given the court officer, but you have to specify on the order. You have to specify exactly what it is that you need to collect. The order must be very specific, and the order must also be able to show in the order who is going to be in charge of that particular operation. So when you go there, you go with you'll get a police officer. You go to the scene, you present it, and you collect the evidence that you need to collect. Except that the scene is always, that kind of scene is always very nasty, because nobody is going to just allow you to collect evidence like that from their machines. So, but the thing is, once you collect that evidence, first of all, what I talked about is the chain of custody, the documentation of chain of custody. How did you, which starts at the time of collecting that evidence. That chain of custody, when it can be established by the court, then it shows the integrity of the evidence. Secondly, you remember the principles of evidence collection, that the process through which you are collecting that evidence should not interfere in any way on the validity or the originality of that particular evidence. That evidence must be able to prove that it is original the way it was collected. So that can be done through audit trails, or the process of showing that by the time I collected this evidence, this is the hardware that I use for mirroring or this imaging. You give the serial number, you give the the model, you give the process through which you mirrored or imaged that hard disk, and then the results, the analysis of the result. If you can prove that to the court without any doubt, then that the court will be satisfied that the integrity of that evidence is maintained. So it is a matter of the chain of custody, documenting everything from the time it is collected to the time it is going to be presented in the court of law, and also the proof of auditability. Now, I'll just give you an example. There's a time I went to court, and I was an expert witness. Now, the prosecution had brought evidence on a CD. Now, when they brought the evidence on a CD, then the device or the gadget that they used to collect the evidence was they did not. There was no serial number. We didn't even know what type of evidence of gadget it is. It was an audio recorder, audio video recorder. There's no manufacturer. There's no label of what serial number. All these were missing on the documentation. Then, what to add more problems is they brought this evidence, this gadget to the court. It was in the court, and then before I went to give my expert witness testimony, the gadget had already been taken. And when they took it, they claimed that this gadget had got some other evidence apart from what they presented in court of law. So the court allowed them to pick that particular gadget. So that was a plus on our side, because we said that how do we now verify that the data which was on that particular gadget is exactly the data that was presented here. So that alone cast doubt on the validity or the integrity of that data, because already the chain of custody has been broken. So when you go to court, what you must make sure is that the chain of custody is intact, and at the same time, you can be able to prove to the third party the auditability of the process through which you used to collect that evidence and bring it to court of law.
You know why I was asking, because I remember the last time.
Yeah.
Okay, thank you so much, Lawrence.
Somebody is talking.
Yes, Lawrence, I was saying thank you so much for that presentation. We don't seem to have so many questions today. Your presentation has been very very detailed concerning digital evidence, admissibility, the types of evidence that the type of digital evidence and everything. We thank you for that, and we thank you for sharing your expertise. We are sure in case of anything, people will be able to get back to you. Since we just have a few minutes to close this session, I would like to remind the people attending the workshop online that we have another training that will be taking place next week on Tuesday, on the 15th. This training will be about digital forensic investigations, how to carry out digital forensic investigations, and the nitty-gritty. The next training is also very important. Today we have dealt with admissibility, adducing it, how we can be able to adduce it before court and make sure that we have the best evidence so that we can sustain our cases. But the next training, we shall be looking at that digital investigation process. Like we have seen from this session, we see that once evidence is not probably collected well, then most likely you might lose a case just because of that. So we shall be going through the digital forensic investigation process. And like I said, you may not be a criminal lawyer, but you may have a case where today you cannot fail to have a case where you have to adduce digital evidence before court. So you must be able to know how to collect it even as a lawyer, and also probably guide the people that will be collecting it in the case. Yeah, so Lawrence will share the slides with us, and also this training session, the first training session and the second training session are available on the East African Law Society YouTube channel, the East African Law Society Facebook page. So feel free to get into there to be able to find information that you missed, or if you joined us along the way. So thank you so much for listening in. That is it for today. We believe it's been comprehensive. as much as the presenter has shared the Kenyan jurisdiction practice, most of them cut across, since most of our countries are picking up in this. So we thank you so much for listening in. I believe that we shall be able to have different countries. In the last session, we'll be able to share views from different countries. So thank you so much, Lawrence. You could give us your parting shots. Thank you.
Mine is just to thank everybody for getting your time to come and listen to us. This is a new area. That's what I can say. This is a new area that that is coming up. So there are challenges. There are quite a number of challenges in terms of collecting evidence by law enforcement, as well as presenting this evidence in the court of law. So that is why we normally do this kind of training. And as I said, I am an approved trainer by the Council of Europe for judicial and law enforcement training in cybercrime and electronic evidence. And at the same time, so I told you that I'm an expert witness in cases involving cybercrime and electronic evidence. So anybody who needs to contact me, I gave you my contact on the first slide, and it will be available, I think, also on the recording. You may be able to contact me, and I'll be able to help you in areas where you need help. Otherwise, I say thank you very much for today, and let's do next week for the digital forensic process. How do you do the investigation? So this is that will also be a very interesting topic to listen to as a lawyer. Thank you so much for today.
Okay, thank you, Lawrence, and thank you to the East African Law Society for organizing this webinar. I would like to thank the participants for listening in, and would like to close here. Today, we shall pick up next week on Tuesday. Thank you and have a good evening.